Welcome to the conference.
Okay, well, let's go ahead and get started. Welcome, everybody. Thank you for showing up on a Monday morning. We appreciate this. As you know, this is the workshop to receive recommendations for changes to the draft regulations governing medical marijuana establishments. I'm Marla McDade Williams, the Deputy Administrator for the Division of Public and Behavioral Health. We're the agency responsible for overseeing the establishment and regulation of medical marijuana establishments. To my right is Chad Westham, Bureau Chief in the division. He will actually, the oversight of the program will actually be under his purview. And then, of course, we have Kelly Bowen here, who has been helping us keep track of everything that's been going on with the regulations. And down in Las Vegas, we have Joseph Thiele, and Joe will be calling people up from Las Vegas when it's time for them to comment. So again, the purpose of this session is to receive recommendations for changes to the regulations. Many of you have questions about some of the requirements that are laid out in the regulations, and you're looking for clarification about what to include in your future applications based on the requirements in these regulations. Because this session is specifically to receive your comments to changes to the draft regulations, we will not be answering those questions for you today. Where we can answer questions, we may answer them over the course of the next few weeks, but where we determine answering questions may cross a line into giving an applicant an unfair advantage in the application process, we'll let you know that we won't be answering the question. And we do intend to respond in writing to many of the questions that we've gotten over the course of the last month or so. As we've received questions and had various levels of conversation about specific sections, it may be helpful to explain what the language of a particular section is designed to accomplish. And if that's feasible to do so during this session, we'll explain what we can. Mr. Westham and I will also may also ask some clarifying questions based on what you're submitting to us so that we understand exactly what it is that you're looking to do. But we will be mindful of everyone's time and not get into lengthy back and forth discussion. So this is going to be more of a one-way dialogue than a two-way dialogue. We do have our own amendments. A copy of that was provided for you. And we have made copies of comments that were provided to us in advance, and those documents we've made available on our website. We also have hard copies here for you as indicated. Some of the documents came in over the weekend or Friday, and we just didn't have time to get everything copied for you or maybe even uploaded. So check the website as you can for updated items that will be linked there. We do need a copy of anything. If you have come and you haven't provided it to us and you're here today, please leave a copy of any of your new comments with us. You can just leave it at the end of any of the dioceses, or you can hand it to Joe down there in Las Vegas. Just verifying here. So we do have this meeting is being recorded, and we do intend to post the recording on our website sometime after the meeting. And then after this workshop, just so everybody understands, we will make changes to this draft document based on the input that we've gotten today. We can't commit to making all of the changes that come forward. There's a lot of decisions that have to go into what we do determine to change or not change. Once we work through that process, we will then submit the document to the Legislative Counsel Bureau, and the Legislative Counsel Bureau will post it on its website under what they call an iDraft under its Nevada register. That draft will probably be different than the one we're looking at today because we do anticipate making changes, but that is the draft that they will then work from to make their document based on our recommendations. Once they work with us, if they have any questions, then they send it back to us. Once we get it and approve it, then we will post the hearing, and that is the hearing before the State Board of Health. Once we announce that, the copy will show up as a proposed regulations document on the Legislative Counsel Bureau's website. That is the document that you then need to be mindful of to direct any future comments about. And again, we'll try to make that clarification through our listserv as best we can. The notice of hearing requires 30 days for us to post. Because we have to have the regulations adopted by April 1st, we don't anticipate being able to, we think we're going to get to the March Board of Health meeting for that proposed draft if we get the regulations back in time. So we're really cutting it close of being able to meet that April 1st deadline. So we're still considering whether to hold a second workshop, but right now, we believe if we do hold a second workshop, we won't meet our April 1st deadline for adoption of the regulations. But it's not something we can comment on at this time because we don't know when we're going to get that draft back. Just again, in terms of the future process, the State Board of Health adopts the regulations. We can make some minor clarification changes at the State Board of Health at that meeting. Once they're adopted by the board, they go to the legislature for approval through the Legislative Commission. The Legislative Commission cannot make any changes to the regulations. So it's essential that we make all those changes at our level if they're going to be made. Once they get to the legislature, all they can do is reject them back to us, and they won't move forward. So please be mindful of that, and we're trying to work the process so that we accommodate as much as possible at these levels, and that we don't get into a situation where somebody waited until the end and then went to the legislature and said, you know, we don't like any of this and you need to reject it all. Again, please make sure that you've signed in. It's what we will use to call you up for today. I'd ask that you stick to the topic at hand. We can't affect changes in the final legislation that was enacted. It has been codified in the Nevada Revised Statutes, and we can't make changes to any of that language at this time. What we intend to do is to have 30 minutes of comments from Las Vegas, then come up to Carson City and have an additional 30 minutes of comment, and we'll just alternate until we get through the day. We will call you up based on how your name appears on the sign-in sheet. And if you're just here to observe and you don't have comments, just give us a wave and we'll move on to the next person. If you have submitted written comments, we don't need you to read every aspect of your written document. If you just want to hit the highlights and again focus on changes to the draft regulations and sections that you want to see revised based on whatever input you have. Again, we have your documents. They will be made available for the record, so it's not necessarily to read all the way through all of them. So, Joe, are you ready?
I'm sorry, Marla. Yeah, we're ready. We're ready.
Okay.
You're ready.
Go ahead.
Ramsey, is it Datus? Datus? Nothing to say? Okay.
I didn't sign in, but I don't want to testify.
Okay, that's fair. Heidi Tangerine, you want to speak? No? No? Okay. Jerry Wynn? John McCain? Paul Monos? Okay. Greg Nelson? Oh, sorry. And Kevin Willoughby, or Willow? You have anything you want to say? Or?
Is that the sign-in sheet? Or?
Yeah, I've got the sign-in sheet here, so yeah. No? Okay. Clint Cates? Paris?
That's it.
No? Okay. Danny Perez? Is that close? Jenny. Maybe it's Jenny. Stan Cooksey? Steven, sorry. My apologies. I'm used to it with my last name, so. I don't know if I need to move this over here, Marla, but I'm going to put it over here for the moment. When you're done talking, I hit the button again.
Do I need to push it? Or is it
No,
good?
it's on.
Okay. I'm Stephen Cooksey, representing the MedMen, and I just had a question. I believe it was in section 26 where it talks about taxes paid or other beneficial contributions to the state or political subdivisions. We were just curious if that could be clarified to what exactly is meant by the other beneficial contributions, if that could be kind of spelled out a little bit better.
Thank you, Stephen. I'm sorry I didn't get your last name, but as we indicated, that's not something we're going to be able to respond to today. It will be up to each individual applicant to respond based on the language that's in front of them.
All right, thank you.
And the last name is Cooksey, Cooksay. Scott Alecki? Okay. Patricia, is it Patricia McDonald, Patrick McDonald? Mr. McDonald, you have anything?
Thank you. I appreciate the opportunity to be here. You already have our written comments. If you have any questions on any of those, I'm happy to answer them or try to answer them. I also wanted to go on record as saying that we also support and also request clarification where John Sandy from Fenimore submitted his comments and his suggestions about changes. We do support those. We would also like to go on record as saying that we oppose the recommendations of Clark County business licensing. You've already got plenty, it's almost as if there's a piling of red tape upon red tape that's going on here, and we're seeing a lot of almost obstructionist reaction from the local jurisdictions to the will of the people as carried out by the state legislature and as is being carried out by the Nevada Division of Health. I also echo many of the suggestions and I would even say complaints about the auditing requirements that you see in so many of the public comments that you received. It's as if you're planning to audit the businesses to death, and there's an overkill of auditing, and we would echo the many suggestions that you received about lessening those auditing requirements. Finally, on the one of the sections, I don't have it in front of me, but the one that deals with not being able to see anything that's in a greenhouse, we would also register our support, and we would like to ask the division to modify that section so that the only requirement is that it can't be seen from a public thoroughfare or from the street, so to speak. As it's written now, I would assume that some of the reasoning that went into that had to do with security concerns, possibly public perception concerns regarding children seeing what's in the greenhouse and what have you. But security concerns, you've already got so many regulations about the requirements for security that in some ways making it impossible to see inside a greenhouse could actually work against security. If you've got a security guard that's patrolling the cultivation facility, you want to be able to see in there. As long as you've got walls or some type of perimeter around the greenhouses that will block the view from the public thoroughfare, I believe that would be sufficient for your purposes. And it almost sounds like what we used to have with bars, where we had to have blacked out windows for bars because we didn't want kids to see people drinking inside, and those kinds of concerns have fallen by the wayside. Additionally, the regulation is written, the draft regulation, it says it could be read to mean that you can't see it from the air either, and we would suggest that you allow for clear as opposed to opaque rooftops on these greenhouses at the very least, so that they can be as beneficial as possible. And I'd be happy to answer any questions about our public comments or any other questions you might have.
Thank you, Mr. McDonald.
Matt Walker? Walker.
Good morning, Marla. Jacqueline Holloway, Director of Clark County Business License, and for the record, Matthew Walker is a Program Assistant to the Director related to the medical marijuana program. Of course, we certainly stand by our proposed amendments, and first and foremost, we would like to appreciate the division for all of the work that they've done, and also we'd like to appreciate and we value the fact that the Board of County Commissioners is one of the first boards in the state of Nevada to allow for the department and the county to move forward in implementing a medical marijuana program. We did submit some amendments. Our first, the first area of amendment that we submitted was that no dispensary shall purchase marijuana from another dispensary. And Marla, do you need for me to read the exact language because we have submitted this in comment?
No, that won't be necessary. Just that highlight is sufficient. Thank you.
Okay. We also submitted an amendments related to aggregate ownership, where we would like for the division to consider aggregate ownerships equal or to or exceeding 5% ownership interest in a medical marijuana establishment. The third area that the department is recommending is demonstrate proof of all applicable public safety inspections required by local ordinance before an establishment becomes fully licensed to operate by the state. I believe that we expanded the language to state that full compliance with and completion of all public safety inspections, which also include and that are required by a local jurisdiction, including but not limited to fire, building, health, and air quality. The Department of Business License, as well as Clark County, believes that it's very important that all public safety inspections have been approved prior to opening or the issuance of a business license. The next area that we focused on is the change in location within 5 miles must be justified and done with land use approval of local jurisdiction that the establishment intends on relocating to. It is customary at this time that any change of location has to go back before the department for licensure, not only for zoning approval, but for also the public safety inspections of those particular locations. Also, we are indicating under the changes in locations within 5 miles, we believe that there should be some justification in writing of the need to the change of location, and of course, as I indicate, land use approval and all applicable public safety inspections must be approved for those new locations. The other area that we proposed is that the division will notify agents and local licensing jurisdictions within 48 hours of an agent registration becoming void. I think that this is very important, not only for the Department of Business License, but also for Las Vegas Metropolitan Police Department to be aware of if we have any changes or suspensions or revocation of agent registration cards. The other area that we focused on is that the division will make available to local government upon request all documents submitted to the division as part of an application for operation of the medical marijuana establishment. We certainly appreciate the division considering allowing for us to receive the application materials simultaneous to the division so that we are in a position of being able to start the vetting process and the local licensing process. That means that we will have a streamlined and efficient system whereby we're able to get the licenses done faster and more efficient. The next area is a cultivation facility shall ensure that marijuana cannot be observed or smelled from outside of the building. We added language related to any odors that are being emitted from the facility. And the final area that we just wanted to place on the record that we recommend that when local licensing authorities and law enforcement enter medical marijuana establishments, that they can enter them unannounced and they do not have to sign in or be supervised as guests as laid out in Section 53. So with that, that concludes the Department of Business Licenses recommendation. Any questions?
Thank you, Ms. Holloway. I don't have any questions. I do want to thank you for your continued cooperation as we worked through this, and just let everybody know that we don't intend to create additional burdens for anybody. We're trying to work with the local governments so that their work, so that we aren't duplicating work. So if they do conduct an inspection, we won't be conducting the same inspection. So it's on us to make sure that the language reflects that way, but that's the intent, that we work together and not create additional burdens for any of the establishments.
And to add to to that, Marla, I do believe that it is both the responsibility of the state and the local jurisdiction to make sure that this program is implemented appropriately, and we take that commitment and duty and responsibility very seriously. So with that, I thank you very much.
Thank you.
Good job. Jonathan and Maria Hale. Jay McClure? No? All right. Angela Arita? Karen Becker?
Is it Harris?
Might be Angela Harris. We'll go with Angela Harris.
Hi, my name is Angela Harris, and I would like to for you guys to take into consideration the use of cannabis for children and autism and things like that, for those being able to put wording in there for children, because there's been a lot of studies and research very recently that we need to be able to put language in there for children to be able to get the medicine. I don't know if you have seen this things on seizures, 300 seizures in a day, these children, and they're putting things on their pacifiers and their food to be able to stop having them have some of these issues in other states already. And so we need to be able to address that. Also, one of the ways that things we need to address is fresh raw leaves. Often it has a provision in here where they have to be able to have, the growers can only have a certain amount of product, even not just the flowers. Well, everybody looks about the flowers and the buds as that's the big medicine. It is for a lot of people, but the raw leaves, there's massive amount of research done on raw leaves, and it's very hard to get them for cancer patients because they die in a couple of days. The people who are growers do not want them. They grind them up and throw them away. There's no money in them for them. But there's no psychotropic effect in them. You can't get stoned from raw leaves. And so it's not a medicine for most people, but for a lot of people that have seizures and a lot of people who have some of the others, it is, and it needs to be made not illegal to be able to keep those raw leaves and have them, because they're garbage. They might as well give them to people who need them for medicine, and it makes it a crime for them to be able to even have it, a certain amount of it. And you have to have a large amounts. And if you're going to grow 7 plants or however many the plants, and you want to do raw leaves, you can't juice and do the raw leaves and have 7 plants. You can't. And so these growers that they're throwing all this stuff away need to be able to provide that without being prosecuted for having those leaves that actually have no psychotropic effect. And also Phoenix tears, when you're making a thing, well, some people call it Phoenix tears, or that black green tar that they use, we call it Phoenix tears. It actually you need about 4 ounces to really make an amount that they can really use, and there's no provision in here for them to be able to possess 4 ounces of the bud and be able to cook it down. And no one will be able to make that type of medicine, where there's a lot of research and a lot of information on that, if we don't increase the amount of cannabis that can be possessed. And then also for the greenhouses, a lot of the CBDs and CBNs, cannabinoids and cannabinols that are used for children's medicine is actually grown outdoors. And so there is a problem with the greenhouses only being enclosed. It's a great way to up the THC in the product and work on that, but it doesn't address any of the other children's problems or the cannabinoids and cannabinols that actually help with patients to actually get better. This is very latest research, progressive stuff, but I feel like Nevada needs to know about it so that we can actually be progressive in our regulations that are coming up. Thanks.
Thank you, Ms. Harris.
Karen Becker? You're good. Vicki Higgins? No? Look for the Didn't see you.
I'm getting tucked in back there. There's not much room. Good morning. I'm Vicki Higgins. Couple of items I would like to address. I think in section 126D and throughout, we should have a quality ID number assigned by the lab as they do the testing. I believe this should follow from the lab to the sale, whether it be in edibles or whatever form. Section 132, I think we should delete to limit the amount of medical cannabis available in Nevada with our tourists is going to be unreasonable. Section 137, I have a real problem with. We're penalizing the doctors who have helped us. We've had a marked increase of patients just since the law has changed. Now, once the dispensaries are open and available, more patients are going to be willing to pay the cost to go to these dispensaries to be able to purchase the medicines they need. By putting our doctors at risk, any doctor that's willing to sign paperwork for patients right now is going to probably back off to protect their practice. These compassionate doctors have put their necks out for us. I do not think that they should be on restrictions as to the amount of patients. I do believe there should be some oversight, but I do not believe they should be penalized. I believe all of the establishments should require handicapped access and restrooms. We would like disabled employees to be able to work as well. And I believe strongly that in this program, we can very easily educate the departments that we will come into contact, i.e. the police department, the marshals, police, I said that already, CPS, the judges, the medical board, all need to be aware, at least at the higher levels and at the supervisory levels, that medical cannabis is a legal medicine and we are legal patients. And I would just like that, I think we could piggyback on the existing programs for these different departments, provide the information for them, and as they inform their people in their monthly meetings or whatever the procedures in place for these particular departments, I do not think the cost would be extraordinary. Thank you so much for your time.
Thank you, Ms. Higgins.
Dan Musgrove? No? Oh. Henry Holloway?
Pass.
Al Brody?
No, thank you.
Adam Steinberg?
Sternberg?
Sternberg, sorry.
How are you doing today? Adam Sternberg. I just would like to also make comment on about Section 137, protecting our physicians here in Nevada. Like Ms. Higgins said, they do an extreme amount of work for our community. They provide an amount of safety that's going to go into this program for the people. 453A.500 states that the Board of Medical Examiners are prohibited from taking disciplinary action against attending physicians on a basis of a physician participating in certain activities in accordance with this chapter. And I just want to, I think the division needs to follow this statute as well. Our doctors are very important and we need them. Let's protect them. Thank you.
Thank you.
Thank you, Mr. Sternberg.
William Horn? Frank Hawkins?
Good morning. In the interest of time, I'll try to be brief. We would like to submit some additional written comments this afternoon. As it relates to Section 24, where it talks about 5% of ownership, we think as a good that it would be a good public policy if all owners have to provide all of the information as to the owners per this proposal that have more or 5% or more. We don't think that you should skirt or allow those folks who may have 2, 3, or percent to not disclose. All the information should be disclosed. Reference to some of the comments that, letters that we read, City of Reno submitted a letter, section 26. We thought that that was a good amendment. Paul Larson of Lima Sawyer submitted a letter, again, relating to section 26, 3, and 35. We thought that those were good amendments. In reference to the Clark County license amendment, we support no dispensary should be able to buy from another dispensary. The aggregate ownership we just spoke to, we think that any owner should have to provide all of the information and should not be allowed to not be on the license or be investigated. Section 33, 4, we support the county's language there about full compliance. 35, their language, we did not support that amendment. And then 136, which talks about shared information. We think that, and I know the county and the state has been working, but all of the applications should be exactly the same, if not 99% the same, because if you want to share information, if everybody has to submit the same information, that might fix or negate that problem that the government seem to have working with each other. And then section 72, we think the language is a little arbitrary and restrictive, and we do not support that language for 72.3. Another letter amendment that was submitted by Patrick McDonald from the law firm of Rainey Devine had a lot of interesting questions and clarifications. We support that letter and wait those answers because we think that that would definitely affect the regulations and the application. And the letter of amendment from John Sandy, from Fenimore, Craig, Jones, Vargas, the same thing except, well, let me say this. We support that because there's also clarifications and interesting questions that would flush out many of the questions that will be asked or have been asked thus far. However, we did not support section 41 and 42.2, 43.5, and 44.3. And with that, I'd like to say thank you, and we'll submit our additional written comments today.
Thank you, Mr. Hawkins.
Jim Ferentz?
No comment.
Patrice Sowers? Gina? Marty Breeze? No, thank you. Tim Romy? Monica Burrell? Thank you. John Hyatt? Yes.
Good morning. I'd like to talk about section 118, which pertains to laboratories. One of the proposed revisions you have that's been submitted is to require accreditation by the ISO, International Standards Organization. Just like to point out that it's very difficult to get a laboratory certified prior to its actually being in operation. And one of the difficulties here is that there are no laboratories doing this work in Nevada at the present time. And so everybody will be trying to get up and running by a certain date. It's unreasonable to require certification prior to that. To post certification to be achieved within the first year of operation, require everybody to be completely certified prior to really being able to be in business, we think is unreasonable. Thank you.
Thank you, Mr. Hyatt. Okay, let's come up here to Carson City. And Eric Edgerton. You'll have to hit the button.
Hello.
You have to hit the button.
Yeah. Hello.
Is it green?
Eric Edgerton here. My concerns were with section 109, letter B, in regards to citing federal regulation directly to the cannabis plant. with the federal government not recognizing the cannabis plant. We run into issues with insecticides, pesticides, fungicides, miticides, and algicides. I was looking for some guidance from the state in regards to what plant protectants we can apply to the plant. In my proposal, it just being a starting point for discussions, maybe we could start with products applied to the plant can only be organic certified and part of the OMRI organization. Any questions?
No, thank you very much. John Sandy.
Thank you very much for the opportunity to be here this morning. For the record, my name is John Sandy, S-A-N-D-E, with the law firm of Fenimore Craig Jones Vargas. I wanted to say this is an exciting opportunity to be involved with everybody here, and thank the local governments and everybody that has been working towards this. It's an exciting process. I will try and make this brief as I've been instructed. A number of my comments, I suppose, are requests for clarification, and to the extent that they are, and there's a way to maybe tweak the language to express more of an intent from the part of the department, I think that would be helpful. I will highlight some of the ones that I've discussed, namely Section 26.2, the process for attestation. First, I think it might be helpful for everybody, rather than requiring 2 individuals in a corporation. It's one of my comments earlier, is to have one point person that is able to speak on behalf of the dispensary, or I guess the establishment. That it might make things a little bit cleaner, similar to what the LLCs propose. You can have a manager designated with the department. But for the attestation in particular, we're asking a person to swear under oath of penalty of perjury to information that he has received from another individual. I think it's an easy enough fix is to just require those individuals that are supplying the information to swear to that via attestation, and allow the person who's communicating with the department to verify to his or her knowledge, and based on the attestations provided to them, that they can swear that all the information they are giving is true. And I do think that kind of will segue into some other comments that I have in a little bit. The next one I'd like to highlight is Section 2610B. This might be nitpicky. I'm not trying to be nitpicky, but we say that they must unconditionally commit these funds to the business. Unconditionally means no conditions. However, I think that there's an implicit condition that they receive the license. So I've suggested some language just to kind of make that clear, and I understand that might be a little nitpicky. I do think there needs to be some clarification as to the $250,000 requirement, because then there's also the requirement that they be able to establish enough or proof of capital for the first year of operation and expenses. Does that mean that's included within the $250,000, or is that in addition to? I think just for all the applicants here, we benefit from that information, so we can provide the proper information that the department is looking for. Next one I'll go to is Section 26, and this is again probably nitpicky, but the language as I read it was referring to an applicant rather than applicants. So the way I understand the process working is with the 40 licenses in Clark County, the 10 in Washoe, 2 in Carson City, is that the department's going to go through and compare all those applications to all the other applications, not just the ones that were submitted by one applicant. The way I think this reads right now is that the department's going to go through, and if an individual or group of individuals have submitted more than one application, they're going to rank those applications 1 to 4, or however many there are, and then assign them a point number, and then do that for every other applicant, and then there's no way to compare. You're comparing apples and oranges. I think the intent was to look at them all together, assign them a point value, and compare them on their applications regardless of whether they submitted more or not. I realize I'm not being too clear on this. Hopefully my letter states it a little bit more clearly. I think it's an easy fix, and I've provided that language. Section 31 and 32, I think, raises an interesting question and just how the department wants to handle it, and that's regarding appeals. Obviously, we probably need to have a system in which somebody that feels aggrieved can seek redress, but what does that redress mean for applicants that were successful in the process? I don't think it's anybody's intent to make the appeals go all the way to their ultimate completion before anybody feels confident enough that they can move forward with the process without having their application revoked by a court. So I think that we need to put language in there that says, you know, everybody's entitled to appeal and we can handle those, and a court can award them a license or certificate down the road, but that doesn't affect the successful applicants from moving forward. I do think that anybody would basically, we want to, because there's going to be such a large capital investment here, we want to make people feel comfortable that they are, if they do things by the book, that they are going to be able to move down the process without some surprise later down the road. Section 34, we use the word fully operational. I just don't know what that means, and I realize that you guys can't comment on that today, but I would request that maybe we think about that a little bit. And also maybe put in some language that if people are working diligently towards completing everything and getting fully operational, however that's ultimately defined, that their license won't be revoked. You can imagine, I mean, we do have some pretty strict timelines, and I know you guys are used to dealing with strict timelines with this, but if somebody's constructing a facility from the raw ground, it's probably not likely that they're going to get all their permits, all their zoning, everything that they need with the local governments, start construction, have their C of O in that 12-month period. So I think as long as they have some certainty that if they are moving forward with the process and not sitting on their rights, that the department's not going to come back and revoke their provisional application. Section 35(1)A, I think this is rather a big issue for everybody, and that's regarding the change of ownership. You know, these businesses will have very legitimate reasons, perhaps, to either bring on new owners or let go of owners that aren't, or board members that aren't carrying their own weight. For example, we've dealt with this a number of times with employee stock ownership programs, plans, ESOPs, to encourage employees to stick around. Technically, under the language that we have currently in 31(1)A, if a business wanted to offer that incentive to their employees, they would have to forfeit their license. We feel that, and I think Mr. Larson had referred in his letter something similar to gaming, where there's kind of a suitability test that, you know, obviously before they become an owner or involved with the business, that they will have been vetted by the state, but that we allow for a process that will allow businesses to bring on these new owners without potentially surrendering their license. So moving on, Section 36(3) regarding the audit. I've just done some, calling around to some friends of mine that are CPAs, and this is, I think this was referenced before, the death by 1,000 cuts. Audited financials are going to be pretty pricey for these small businesses. I got a range, and it's obvious you can't tell because they're all different, but between $25,000 and $50,000 annually. I think that this is going to be a huge amount of capital up front with no prospect of making any revenues for quite some time. And if we continue to pile on these little expenses that they add up over time, hopefully there's a way. I know there's people that are involved more in the financial field that might be able to give the department the comfort that they need, that these businesses are being run properly, but hopefully minimize the expense that an audit would require. I've made one suggestion, but I'm sure there might even be some better ways. Section 37 regarding inspections. Definitely don't want to stand in the way of the state, local governments from doing their jobs and making sure that these places are run appropriately. However, I foresee a disruption in business and some patients feeling a little bit on edge when people with clipboards and official-looking badges come knocking through while they're trying to shop for their products. If there is a complaint or something, I fully support anybody being able to come in unannounced. However, if this is just the annual inspection and the department and local jurisdictions are doing their best, I would hopefully prefer that they try and be mindful of the business and maybe conduct those inspections and audits off of business hours. Just something food for thought there. Section 41, 42, 43, and 44 as it pertains to residency. You can see the description that we've given. I know that the legislature has, from the very time they considered 374, contemplated out-of-state individuals participating in ownership of these businesses. Most of these people with experience in this industry and the people that are going to help us build this industry are going to be from out of state. I don't think that it was the intent of the legislature, and I don't think it's your intent to make it more burdensome for out-of-state people to participate. And so with respect to those, we just want to clarify that it's not the intent of the department to impede non-residents from participating. Moving on. The agent card is an interesting thing going through the legislation and also the department's guidelines and the regulations as to who's required to have an agent card. I know there was language, I think anybody with a contract. So that includes a whole number of people that I don't think is really appropriate, that the department really wants to take the time to require them to get a card. So I made a couple of them, named a couple of them, but obviously attorneys, CPAs, but it even extends to security. If you're contracting with a security company, if you're contracting with a janitorial cleaning company, I mean, you can imagine how many different, the packaging folks, and they're going to have a contract. I don't know that those people are touching the business in such a way that the department would really want to spend the time reviewing them and requiring them to have agent cards. So I think that it needs to be limited to the people that are actually conducting the day-to-day operations of the business. And that kind of segues, and I know the legislation definitely contemplates, I don't know if it ever specifically requires it, but it definitely does by the language, contemplates board members having the agent cards. I don't have a problem with that necessarily, but I could see a situation where somebody that doesn't necessarily have experience with medical marijuana might be a valuable member of a board, but for the requirement that they're going to have to register with the state, it might just impose an impediment for them, and we might not want to prevent somebody who would be qualified and beneficial to a company from not participating simply because they have to get an agent card. So something to contemplate, and that, like I said, it seems that the legislation contemplates that, so that might be a legislative change. But I think if I spent more time going through the statutes, there's probably justification to maybe not have that requirement. Section 67(3)(b), the information that's distributed at point of sale. I just am curious what the department contemplates providing to a patient and whether they have to provide it to them every time that they participate or purchase from a dispensary. If they've established a relationship, I don't think we want to require a business to continually send them information that they might already have themselves. So might want to just clarify that and see how that's going to work. Section 72(3) has already been discussed, but that's the visibility from outside the building. It was quote unquote building. I think we all recognize that a number of cultivation facilities are going to be in greenhouse. I've been told that some greenhouses do have opaque sides that wouldn't be visible from outside the building, but some are clear. And there are probably reasons why you would want to have that. So as long as the cultivation or the medical marijuana establishment prevents visibility from outside the property, from a public thoroughfare or something, don't have a problem with it, but I just don't think the regulation contemplates a greenhouse that does not have opaque sides. So wanted to make that. Section 81, the license for infused and inedible products. I don't know, there's obviously the requirements for education and making sure that safety, food safety is accounted for. However, if a establishment is only engaging in infused products, we would request that the department try and clarify that as it relates to the food safety requirements, that those wouldn't be required for somebody that does solely infused products. And just want to clarify that. And so those are my high points. There's more in my letter, but I definitely didn't want to waste your time today. And I'm sure there's a number of other people to speak. So I really appreciate the opportunity again and look forward to working with everybody in this process.
Thank you, Mr. Sandy. Yvonne Murphy, you're passing. Okay. Lee Lockhart, passing. Farrell Vaughn, passing. Derek Connor.
Good morning, Derek Connor, the law firm of Connor & Connor. I want to comment specifically on Section 137, and I promise I will be brief as well. I'm concerned with the way it's written, that it's basically it's going to be a quota system to where you're just going to submit reports on these doctors every year for people that happen to recommend large amounts or high number of patients. I think that the division should take into consideration the individual practice areas of the doctors. For example, an oncologist or a pain management doctor would be expected to make a lot more recommendations than, say, that's fundamentally we want medicine to be based on medical science and not on a quota of patients that are treated. So that's pretty much all I have to say.
Thank you.
All right, thank you.
Chris Cassidy. Greg Salter.
Good morning. Greg Salter with the Washoe County District Attorney's Office. We're wondering if the division has determined the number of cultivation, production, and testing facilities that will be needed to support the dispensaries. We're trying to plan ahead to see how many cultivation facility applications we may be getting, and wondering if the division has made a determination yet.
We have not.
And then my second question was if somebody has a change of ownership and they submit during the 10-day period for the next year I guess it would be for a renewal. If the renewal is rejected, what happens then? We're curious about that.
As I understand the regulations, then we have to open up a new application period to fill that spot, or we have the option to go to the next person in line.
Okay, thank you.
Carrie Richardson. Pass. Greg Sayabelian. Pass. John Sutton. I feel like a baseball announcer. Shane Johnson, Megan Salcedo, you're on deck.
Good morning, and thank you for the opportunity. So I will submit additional written comments later this afternoon. Just touching briefly on 4 sections, starting with section 35(1)A. Others have hit on this. I appreciated John Sandy's comments on this as well. We request a revision here. As detailed within this section, a medical marijuana establishment must surrender its registration certificate and reapply during the next annual 10-day application period before an additional person gains an ownership interest. Implemented, this section creates many adverse consequences, and I've called out a few in my written documentation, but I'll skip them. As a revision, we ask the division to consider the amendments provided by Leland, Paracchini, and Steinberg LPS that we all received when you published the grid the other day. That was submitted on December 17th, 2013. I'm going to paraphrase it here for the record. In my opinion, LPS recommended standards used in other regulated industries, and to expressly require a transfer of all or substantially all assets and not less than 10% of the stock of the MME to trigger it, In addition, any new owner would need to be thoroughly vetted for a new MMEA agent card, and rather than disrupt MME operations, the new owner cannot participate until they pass the state's vesting process. Moving to Section 41. Section 41 states that each medical marijuana established agent registration card issued pursuant to NRS 453A.332 must indicate the category of the registration card. The person to whom the card is issued may only provide services at the type of medical marijuana establishment for which he or she is registered to provide services. Per our discussion Thursday, this is important to us because we have and will propose a full seed to sale operation. And from the standpoint of cross-training, providing access, we would ask that the state consider modifying or expanding this provision, again, Section 41, to enable registered agents to work in multiple establishment types if the umbrella organization encompasses several different types of establishments. Moving to Section 50, and here I'm requesting additional clarity. Section 50 stipulates that American marijuana establishments shall not use, 1, a name or logo unless the name or logo has been approved by the administrator of the division, and 2, any sign or advertisement unless the sign or advertisement has been approved. The reason I'm asking for clarity on this is just typical business process. It's my intention to hire headcount, hire consultants and content developers to be able to begin talking about marketing campaigns that our plan is to utilize, assuming that we get the go-ahead through your agency. So I would ask that you provide clarity around the types of advertisement that will be prohibited downstream, both content and the method of deployment, i.e. internet-based, social-based. Also, some definition around the process and the timeline to secure advertisement approval, and that's post-license. So in effect, then, what is the workflow? This guidance enables my team to earnestly work on marketing planning at this juncture, secure budgets and talent, while helping us avoid a costly campaign build that then cannot be implemented. Lastly, Section 72, subparagraph 1 and 2. Here I'm requesting a revision. As stated previously, our proposed business footprint includes edible infused medical marijuana product manufacturing, dispensaries, and a cultivation facility. And I'll just cut to it from a business and safety perspective. After doing an exhaustive analysis with several qualified ex-police officers, FBI agents, etc., on the increased security risk of bifurcating a medical manufacturing establishment and a cultivation facility, I would recommend from a business and a safety perspective, I ask that you consider amending Section 72 to allow for those specific complementary businesses to share a common entry, common amenities like a team break room, bathrooms, and indeed a common building. And in our prior conversation, I think it was last Thursday, you did mention that you had some definition in terms of a legal definition. I look forward to seeing that publication. Unless you have any questions, again, thank you very much. I hope everyone has a wonderful Christmas. Thank you for hearing us out.
Thank you, Mr. Sutton. Shane Johnson.
Good morning, and thank you for taking your time over this holiday season. I have a number of comments. I submitted them also via email this morning. I won't belabor you with reading every single one of them, but I'd just like to touch on some of the highlights unless you need me to go over them in more detail in this setting. Section 2, I'd request a revision. As it's currently written, the definition of batch could be taken to mean myriad different strains of marijuana that happen to be grown at the same time, which in my view is illogical. So I would like to suggest language that batch would mean a specific strain of marijuana grown from one or more seeds or cuttings that are planted and harvested at the same time and grown in the same location under the same conditions. Other people have already highlighted section 36.3, which has to do with the audit. I have proposed some specific language changes there myself, but just want to highlight that that is a concern, especially in the startup phase of operations. Section 40, I would request clarification. Please add the clarification that there is no requirement that a medical marijuana establishment agent be a registry card holder, e.g. a patient. Section 42.2, I would also request either a deletion or clarification. There should be no restriction that a medical marijuana establishment agent be a resident of Nevada. So either please delete this provision or specify that the business address of the medical marijuana establishment is sufficient to meet the requirement contained therein. Section 79.1I, request a revision. The serving size and number of servings will vary greatly based upon the patient and the condition being treated. For instance, a child with chronic seizures versus an obese individual with episodic or severe pain. I would suggest deleting the first portion of the clause and revising according to the following. The total milligrams of active cannabinoids and terpenoids per unit as provided by the independent testing laboratory that tested the product. Section 115, I would request a revision. In the context of medicine, the term, quote, laboratory-based stability testing has very specific connotations. Such testing costs tens or even hundreds of thousands of dollars in months of time for each product tested. This is untenable and unnecessary, especially since there are no standards established for laboratory-based stability testing of dried marijuana products, and in the instance of edibles, the expiration date should be based upon the characteristics of the food items themselves. My suggested language for this section reads as follows. Each cultivation facility for the production of edible marijuana products or marijuana-infused products, and medical marijuana dispensary shall, to assure that a medical marijuana product meets applicable standards of identity, strength, quality, and purity at the time of use, ensure that the product is labeled, in the case of dried marijuana flower or concentrate, with the packed on date or manufactured on date, respectively, and in the case of infused or edible marijuana products, with the manufactured on date and an expiration date based on similar products not containing marijuana. Section 132, I would request deletion as long as no diversion is taking place, which is a wholly different issue. There is no need for a limitation on production by the division. Normal market forces of supply and demand will adequately address that issue. With regards to some of the previously published comments, I'd like to specifically call out the couple of comments by Vicente Sederberg. I oppose their rationale and suggested amendments as they pertain to Section 73.2. Specifically, their modification would require that plastic be used for packaging. We believe that the use of plastics should be optional and, in fact, limited where possible in favor of inert materials such as glass. Also, Section 131, they propose that 14% THC equates to 10 grams of THC. They're confused. I mean, the reality is that 14% isn't based on the total weight of flour, but it's based on the oils. So I believe that your original language there is adequate. With reference to Clark County's proposals, I would oppose their new stipulation that requiring that no dispensary shall purchase marijuana from another dispensary. All of these products have been tested by independent laboratories, and to the extent that one dispensary desires to purchase and another to sell a given product, there should be no prohibition on such sale or transfer of product. I also oppose their Section 33.1 amendment. Your original language is adequate. To the extent that local jurisdictions wish to add their own additional stipulations, it's certainly within their right to do so and will be part of that local permitting process. I'm also opposed to Section 72. Clark County's desire to add a phrase disallowing a cultivation facility to emit an odor that is detectable is far too broad and prohibitive. I happen to work with canines, and I'll tell you, a canine detection dog, detectable has a very different connotation than somebody walking by on the street outside of a property boundary. So I would oppose that suggestion. These are not in the written comments I've sent in, but I also support Todd Urin's comment regarding Section 62, 1D one, requiring the workspace to be sanitized. He suggests that other language would be advisable, for instance, cleaned thoroughly or something to that effect, and that would be more appropriate. Plants thrive best in conditions that have bacteria, both good and bad, just like we humans do. And so to have something that is sanitized, again, that has a medical connotation of more aseptic conditions, which isn't entirely realistic. That is it. Thank you so much for your time. All my other comments are submitted via email.
Okay, thank you, Mr. Johnson. And we'll go to one more. Megan Salcido.
Thank you, Marla. Megan Salcido, representing the City of Reno. Just want to thank Marla and your staff for all your hard work and the level to which you've engaged with the local governments in addressing all of our concerns. We're very appreciative of that. We have one small amendment that we think is significant. We think it will help make the process more business friendly and reduce the burden on applicants. And that would be in section 26, subsection 13. We propose adding language to specify that zoning restrictions refers to zoning restrictions concerning medical marijuana establishments. The concern is that if zoning restrictions is interpreted as any city having any zoning restrictions, that would apply to virtually every jurisdiction in the state. I think there's just a handful of maybe some rural counties that don't have zoning restrictions, and that would force applicants to go through the entire land use and business licensing process before even applying to the state for a certificate, and that would be a costly endeavor for these applicants prior to knowing whether they will get one of the limited handful of state certificates. And so I think it would also flip the review process that's intended by the regs as drafted. Instead of applicants going to the state and going through the merit-based criteria process and then moving on to a local jurisdiction, applicants would come to the local jurisdiction first and then be sent on from local governments to the state process. And so I think that would limit the number of applicants that would eventually make it to the state process and limit the number of applicants that the state would be able to evaluate. So that would be our suggestion on the language. There might be something else that could be added to further clarify, because I don't think the intent of the Health Division is the way that we're interpreting the language, and there may be some other clarification that would work better than what we've suggested. Thank you for the consideration.
Thank you. Okay, Joe, back down to Las Vegas.
That button back on. Steve Fuller. Pass. Brandon Parcell. Charlene Lewis.
Pass.
Howard Schutz. Angela Harris. Oh, it's me. The other one wasn't it? Susan Johnson. Serena Choi. Clay Guston. Pass. Kathy Gillespie.
No comment.
Gillespie. William Fonte.
No comment.
Chris Fancy.
Thank you.
Francie. Joe. Begins with a C. No.
Josh Collins.
Is it Josh? It's like Joe.
Probably my chicken scratch. Yeah, that's me.
Okay.
Joshua Cohen, an agent with Jack Holler Commercial Real Estate. I'm helping a couple groups find locations. There has been some concern or some confusion as to whether someone with a limited gaming license can also hold a dispensary license, even if they're not in the same location. As I understand it, they would both be legal under separate jurisdictions, the dispensary under you and then the gaming under GCB. But we haven't been able to get any clear answers from the state government as to whether they will both be allowed at the same time. Second is starting up operations. I believe the amount that's going to be allowed to be purchased as a one-time thing, it was allowed to be purchased from a caretaker or someone with a small local grow operation. There's been concern that that will not be enough to start up an entire operation for multiple dispensaries, and that there might be some sort of gray area where people can make one-time acquisitions, either black market or out of state. I don't know what the specific decisions are going to be on that, but we would like some clarification. Under the jurisdictions that are, the local jurisdictions that are not issuing permits right now, assuming the state laws and regulations will take precedence, does that still require a local permit to open? Or can everything fall back on state, and can these operators just say that we have the state permit and the city can catch up later? Regarding verifying out-of-state IDs on reciprocity, we'd like some clarification of what will be required, whether that's just an affidavit or if additional steps need to be taken to prove that the dispensary has done their due diligence. Clark County had discussed limiting hours of operation. We strongly oppose this. We'd really like shops to be open 24 hours if the local property allows it. There's no reason to limit that. Pharmacies are open 24 hours, and I don't see any reason to create a blanket restriction on it. The other thing that seemed onerous was only being able to change dispensaries once every 30 days. That really limits an individual patient's opportunities and choices. And then as far as the 10-day window only being once a year, there will be certain times when locations need to change location. And if that happens a month after that period, that means they have to wait a full 11 months to get a new certification just if they're moving down the road. That seems a little onerous. So unless you have any questions, that's it. Thank you.
Please spell your last name.
Cohen, C-O-H-E-N.
Mr. Cohen, I would ask you to look through the regulations. We have addressed the non-resident verification. So if you could find that section and see whether or not it meets your concerns. It doesn't speak to an affidavit, so I'd ask you to look at that one again.
Okay. All right. Thank you.
Thank you.
It's going to be Joe Caldwell or something. Joe? I'm going to go back to the, okay. Brian O'Callahan. And I'm not going to attempt these three. If any, we'll come back if I don't get to you. Lizette Mastros? Brian O'Rory?
Okay, no comment.
Dina Woodbury?
No comment.
Rick Brewers?
No comment.
And there you are. Dave Holm?
No comment.
Sure. Kristen Albion?
I'll speak for Chris.
And you are?
Cool.
RJ.
The famous RJ.
Yes.
Oh, gosh, famous, very infamous. Sorry.
There you go, RJ.
Okay, I'll try to get to the point on certain sections. Well, starting off topic, in Arizona, we're actually trying to fight the audit system that they're imposing on the dispensaries currently. It just seems that it's a undue burden to spend $30,000 for an internal audit with DHS, and a lot of the dispensaries are teaming up together to kind of eradicate that, because it's inevitable that the IRS is going to audit us at some point in the next 3 years, regardless. So for us to spend, $20,000 to $30,000 to $40,000 individually to do that for each dispensary, undue burden on the dispensary. To start on that subject, and then to go to actual section 26, plan for testing and business plan. I understand we're gonna have to go through a regulated Nevada testing facility, but it would be nice to clarify plan for testing, because it is possible to put a testing facility within the cultivation, so it doesn't really clarify that too well. And then I'd go to section 36, proposed hours of operation. The sooner that's clarified, that'll definitely be of assistance for sure. Let's see. Now to get to an interesting point that we've been digging through in the back over there. Okay.
Section 57, number 2, a medical marijuana establishment shall acquire marijuana, edible marijuana products, or marijuana-infused products from, obviously another medical marijuana establishment, but then it says a person who holds a valid registry identification card or his or her designated primary caregiver card. So you can get it from the caregiver, we understand that, but then it states in the actual NRS code that the patient or caregiver cannot receive any compensation for that product. So how are they actually supposed to sell it to the dispensary if you're not allowed to receive any compensation? So there's some clarification on that and how to actually distribute that product to the dispensary would be hugely beneficial. And then to go back to section 134, it states the division may change and collect a fee from any medical marijuana establishment that is involved in a complaint submitted, or what is the fee? Could it be 500? Could it be 5,000? How to clarify the fee and why the fee is imposed for a complaint, or is it a sliding scale, a different severity of a different severity of complaint? So that way we know what we're expecting if we do receive that, because it is a possibility. So that's all I have now at this moment. I'll come back if I get some more. Thank you for your time.
Thank you.
Delos Benedict?
Good morning, Delos Benedict. In reading through the section on concerning independent testing laboratories, I don't see anything at all that would prevent over-familiarity between the edibles establishments and the cultivators and certain laboratories that they might like to use over and over again because they like the results that they get from that one particular lab. Maybe they should be required to use different labs and share that information with other dispensaries so they're getting the same result no matter who submits the sample, etc. That's about it.
Thank you.
Thank you.
Matthew Rhodes? Ivan Nathanson? Nicholas Bird? Richard Fitzpatrick? Oh, I'm sorry.
That's fine. Just spoke up. Nicholas Bird.
Thank you.
I have a question that, as far as I can see in the regulation, is only somewhat addressed in section 54. 1B talks about business records. Currently, the state of the regulations in the country, according to FinCEN, the Department of Justice, is that no business can utilize a banking facility due to the nature of the product that we're talking about. My question is there clarification, or could I get clarification on the situation currently in Nevada having to do with the banking regulations? Colorado is proactive. Governor Hickenlooper is requesting some clarification from DOJ having to do with this issue. Is Nevada involved in that at all? Are they trying to get information or clarification on the subject?
Mr. Bird, I know that we as the division are not directly involved in that. I presume that there are others in the audience more familiar with what other efforts that might be going on, but as the division, we are not involved in that.
Thank you.
Richard Fitzpatrick?
Good morning. I appreciate the very transparent and user-friendly process that you have, the division are taking on this. There's no question that the primary beneficiaries, the people in the state who will be the patients who receive this medicine, they're the ones who will benefit the most from the implementation of this new law. But beyond that, there is the potential that this law can create hundreds of new businesses and thousands of new jobs in our state. And that's a good thing. And the more of those small businesses, the better. But beginning in Section 33, there seems to be a real weight upon the very wealthy, large corporate interests that could already own a building or already have signed a lease, not even knowing if they're going to get a contract, not even knowing they're going to get a license. The suggestion that I make there is that you could have an option to buy property or an option for a lease predicated upon getting a license from the state. So that will allow many new businesses, many are smaller groups, because they don't have to officially have total ownership at the time you approve them. By the time you officially allow them to open, they can have that. But I think that would be a real step forward. In Section 115, you talk about the expiration date, and that's perfectly fine for edible products. Brownie, a cookie, a drink, a sap should have the same requirements whether or not they have cannabis in it. If there is a requirement for an expiration date on a tea bag, if it has cannabis or if it just has other herbs, there should be no difference. But when it comes to the flower, there really is no established credibility of any of the standards, even the tests, the very expensive tests that you recommend in there. There's no valid data, nowhere, not only for cannabis, but for any of the botanical products. The FDA does not require ginseng or hops to have an expiration date because they say there's no credible data. No one really knows. So there's no reason for the flowers to establish an expiration date. Anecdotally, I've seen 30, 40-year-old cannabis products that still have plenty of potency. In 118 on the accreditation of labs, the ISO national standard, it's what Nevada uses to accreditate labs that test cigarettes. It's what Massachusetts is now using to accredit labs. So your department, the division, doesn't have to set up its whole intricate process of overseeing them if you use an international credibility of the ISO certification. Now, this morning, Mr. Hyatt made some good points about in our state, where we're just starting out and it's new, that it's very difficult to have that kind of accreditation. So I think in the first year, if an applicant was under contract with one of the accrediting agencies that could accredit the lab, and if they finished that within 1 year, that would really accomplish both. Because while they're being accredited, they're going to be on their very best behavior. They'll be performing at the highest level, and that will allow us to have a really solid, credible set of labs. And then finally, on one matter in Section 121, actually it's two matters. One is you set the testing immediately prior to manufacturing. It really doesn't make any sense. The manufacturing, the creation of a product is going to alter it. So if you took a test of its active ingredients and a test of its safety, then you put it through a process of extraction or a process of mixing with other products, in infusion, it is going to be very different afterwards. So why would you have a test before all that takes place? The valid place to do the test, what's really important for patients and for their doctors to know what's on the label, is immediately prior to packaging, because that's what goes in the package. That's what you want to know is safe. That's what you want to know the active ingredients is immediately prior to packaging. And then also in that section, you talk about the agent of the grower being the one that takes the samples. Scientifically, that's not really how we do it. As a lab, if we're going to say that this is representative of an entire batch, one of our representatives has to take that sample. It has to be an independent person. I mean, many of these growers are brilliant and very intuitive. They could look at a 5-pound batch, which, by the way, I think is too large. I really think a batch should be a kilo. Washington's compromise of 3 pounds is good. But out of 3 to 5 pounds, I know growers, if they were taking the sample, they could cherry pick really well, and that probably wouldn't be representative of the entire batch. So the objective, fair way to do it is to have the testing lab do it. Finally, many of the things you've heard on audits we would agree with. It could be a review or a compilation. The residency for both consultants and employees should be gone. The ownership changes. A 10% threshold would probably work. So I'm happy to submit these. Another area is just technical. In the testing area, there are just absolute conflicts in the language. In one place, certain tests are called mandatory, and another place in the regs they're called optional. We can't comment it because we don't know which one it's going to be. And the labeling, frankly, is a mess. It's really hard to understand what label is supposed to go on what product and what should be there. I'm sure it could be just made much clearer for all of us so we know this type of product should have this label. And right now, I've read it over and over, and I don't really see what that is. So thank you very much for your consideration, and have a great holiday.
Mr. Fitzpatrick, I do have, I guess, a couple of comments. Where you do you mentioned conflicts in the language. It would be helpful if you would at least just point those out for us. I don't know if you've done that in your written recommendation. I know we've worked through some, but it's only helpful if you tell me which sections you believe are conflicts so that we can address those. And then we missed which section you were talking about the immediately prior to manufacture for testing.
Okay, that's right there in 121, where 121.1 was saying immediately before manufacturing, and now I would recommend it says immediately before the final packaging.
Right,
and as
that's
far
fine. Thank you.
Sure. And as far as the conflicts, I'll put them in writing. Our friends at Steep Hill Labs also submitted their concerns about some of the conflicts in the testing language too, but I'll get that to you by the end of the day in writing of some little technical things.
Okay, and I appreciate your comment that labeling is a mess, but I guess I need some more specifics, so if you could invest in that as well, that would be helpful.
I would be happy to. Thank you.
Thank you.
Todd Case?
No comment, thank you.
Gale? Bruce Gale?
Yes.
Good morning, Marla, Division of Public and Behavioral Health. I want to thank you very much for allowing me this opportunity to speak again, and the Herculean task y'all have taken on and the major changes since the October 1st draft of the regulations. I believe it was on November 22nd I received your email with the second draft of the regulations, and I don't have my comments in front of me, but I have two major comments, and both of these issues have been addressed somewhat previously today. The first major concern I have is Section 35, subsection 1, and that's regarding the requirement that a medical marijuana establishment surrender its medical marijuana establishment registration certificate under one of two conditions. I think it would be better that if, the Division of Public and Behavioral Health, they've vetted everyone, they've issued them a medical marijuana establishment registration certificate, and under SB 374, the certificate's non-transferable. But if there's going to be a change in ownership, as other people have commented, I think it should be similar to Nevada's gaming regulations and gaming statutes, that if there's going to be a sale of a licensee or assets of a gaming establishment, let the applicant submit an application and let it be reviewed by the Division of Public and Behavioral Health. This way, the medical marijuana establishment doesn't surrender its certificate. It continues as a going concern. The Division of Public and Behavioral Health can do its due diligence and review the proposed change of ownership interest and determine whether or not that applicant is suitable or not. Secondly, I would suggest that Section 35 be consistent and take into consideration Section 24.1, that the regulations only apply to an individual that has more than a 5% ownership interest. So, again, 35 subsection 1 be applied to someone who has more than a 5% ownership interest, but then also under Section 24.2, the division can determine if it's in its best interest to vet this person if their ownership interest is less than 5%. The second major comment I have regarding Section 35 is subsection 1A and B. And it's the one word, and. I don't know if that word should be or, but the way Section 35, subsection 1 is drafted is, and there's a change in ownership and a material change in location, that the establishment has to surrender its registration certificate. I don't know if that was intended to be or, but that would seem to make more sense. Again, I'll leave that up to you and the Division of Public and Behavioral Health's judgment. The second major comment or area of concern I have, and again which other people have addressed today, is Section 36 and the requirement of an audit. I can tell you that I haven't practiced as a CPA for many years, but I used to do that in Las Vegas. And assuming the law is still the same, that there's basically three types of, I'm in favor, let me paraphrase, let me back up. I'm in favor of subsection 2 of Section 36, that, annual financial statements be submitted in accordance with general accepted accounting principles, The audit requirement under subsection 3, I'm wondering if the Division of Public and Behavioral Health might want, in its own discretion, maybe just modify this language to require a review by an independent certified public accountant. Again, I haven't practiced in many years, but assuming the three types of reports that are issued by independent certified public accountant are a compilation, which is just where the numbers given, the data given by the establishment are put on the CPA's letterhead, and then the review where there's some more procedures performed, but short of an independent audit. Now, the cost, I've heard some figures flying around today, $25,000 to $50,000 for the cost of an audit. I don't know if those are accurate or not. I know it's going to be in the thousands of dollars, maybe the tens of thousands of dollars. And the first year audit for an entity is going to be the most expensive audit. Because the first year audit, the independent certified public accountant has to obtain and create basically a permanent file where it gets copies of documents, agreements, leases, ownership documents regarding property, various documents that are going to be useful to the independent certified public accountant, not just in that year and years to come. So I think if the division considers possibly only requiring a review initially, and then maybe its discretion requiring an audit, that's a possibility. Or maybe requiring an audit for the first couple of years, because those might be the most important years of operations, and as far as the division is concerned, whether the establishment is going to continue as a going concern, maybe it should consider that. Now, I guess also related to this is somewhat under Internal Revenue Code Section 280E. The reality of the matter is any medical marijuana establishment that operates, let's say for the calendar year ending December 31st, 2014, is going to file its tax returns in 2015. And it will, unless there are changes to Internal Revenue Code Section 280E as proposed in Congress at the current time, the medical marijuana establishment, they're going to get a deficiency notice from the Internal Revenue Service. Because as you well know, under Internal Revenue Code Section 280E, no deductions are allowed, which would ordinarily be necessary in ordinary business expenses under Internal Revenue Code Section 162A. The only deduction allowed is cost of goods sold. So the Internal Revenue Service might be doing, looking at the financial operations of a medical marijuana establishment just as much or even more detail as the Division of Public and Behavioral Health. There's two U.S. tax court opinions regarding medical marijuana establishments at this time, and those pretty much address some of the issues that the Internal Revenue Service is concerned. And that's it. Those are my comments.
Thank you, Mr. Gale. So for the moment, I'd like to take just a 10-minute break, and then we'll come back to Carson.
No, or internal revenue code section 288. Yeah.
What was the other one?
Well, that
IRS code you quoted, you go to all businesses or just nonprofit?
we could have.
That is with them home.
Excuse me, I'm sorry.
That's all right.
That's actually one of the things. Great, nice to meet you. See you again. Oh.
Get you two up in northern Nevada. This is a good thing.
Here, you're going to put I just wish I knew more about it.
Okay, let's get going again. In Las Vegas, are you ready?
We're ready.
Just a quick comment before we take our next commenter. Recognizing that not everybody has had an opportunity to work through all of the comments that are coming forward, we are going to set a hard date of December 30th for accepting any more written comments about, what you reviewed out there. But it is a hard date. I can't wait beyond December 30th, and hopefully we have your comments well before then so that we can actually get this document to the Legislative Council Bureau with the revisions that we intend to make after today's session. Okay, so we are back up here in Carson City. Jake Ward, pass. Ryan Adams, pass. Tobias Paquette, pass. Gary Lambert, pass. Peter Kruger.
Good morning, Peter Kruger for the record, representing the Nevada Medical Marijuana Association. I'd just like to ask in the fact that many of my initial comments have already been addressed, but to ask the division be mindful of the rural. One size really doesn't fit all, and I know that the legislation doesn't really address that, and you can't go much beyond the legislation, but keep in mind that the concerns of the rurals when it comes to cost, especially in areas of transportation, audits, laboratories, in discussions, how many laboratories we'll have in the state, the transportation of product, and other associated issues that have come from our rural counties and their ability to provide the public with medical marijuana and address their patients' needs. The second area I wanted to address was your scoring criteria and the point values. I know that this is something that all of us that have an interest in this area and our clients are interested in, is that to see those numbers and to the degree that sooner would be better than later. We'd ask that you consider that request to allow those interested parties to see what that criteria is going to actually be point by point on each criteria. And those are my comments, and thank you very much.
Mr. Kruger, so on the point value, the regulations say we're going to release it when we announce for applications giving 30-day notice. Do you want longer than 30 days? You want it now?
Yes, ma'am.
Also, Mr. Fitzpatrick, if you're still in the audience, if you could also, in your written documentation, identify the sections of the regulations that would not be needed if we required accreditation by the ISO, that would be helpful, because I think there's a lot in there that may go away if we move to some other accreditation. Okay.
He'll do that.
Thank you. Hugh Hempel. Lindsay Knox. Dan Newell. Lissa Davis.
Hey, Marla, we've lost audio.
I'm sorry about that. I have to start over. It's public speaking is rough on people, and it is. But that is my feeling is that the agent should not be restricted to the actual dispensary or to any of the other three groups. That you should be able to get an agent's license. Say your boss isn't the best boss in the world, then you would be able to walk out of there with your agent card and go ahead and go work somewhere else. I do have some changes to make, and I will go ahead and you've got some words that are incorrect and in places, and I'll go ahead and send that through. But that is my look on this. As a patient, I'm not sure that I'm going to be very happy paying $400 or $500 an ounce for this medicine. As a worker, I can't get a job in a lot of the places in this town because I have to have a drug test in order to get a job. But in this industry, this is a place that people who are patients, who understand how this medicine works on them, will be able to get jobs. And that's why having their own agent card is beneficial to that person. You could go ahead and then upgrade, say that you had, done something well in one place, then go ahead and upgrade your card to the point where you would be able to work in any of the 4 facilities. Also, your pricing is extremely high. I would like to see, if you are a patient, you've already been through the police reports, you've had your fingerprints taken, I would like to see the pricing for a marijuana patient to be $25, and I would also like to see the renewal annually for $25 because that paperwork has already been done. Also, there is the idea that, and I'm sorry, I just have to read this one thing that I wrote. You have a place where you have the origin and strain of marijuana seeds and marijuana cuttings planted, and that is going on your, that's in section 57.4, point D, point 3. I've seen that you've said don't ask, don't tell in some earlier hearings. Would putting the word unknown there for the first couple of years work? Because you're not going to have that information if it fell out of the sky and suddenly there it is. Also, what are dispensaries allowed to sell besides medicine? Are they allowed to sell? You have paraphernalia, and that's something new that has been in that gray area. Are you going to be able to sell T-shirts, cards? You're going to have pipes. The dispensaries that I've been used to using in Oregon, there was no paraphernalia. They had T-shirts, but that was it. You went to a different store to get your paraphernalia. I also visited Arizona in May, and because they are a reciprocal state, I called a couple of the dispensaries. They were disorganized. They didn't know what was going on. I would hope to see that when we roll our program out, that we are much more friendlier to our reciprocal people that are going to be coming here, because that's really what we want to be able to do, is give patients medicine where they don't have to bring it from another state, which is against the law. Also, you have in section 134.1 a complaint division there. I would ask that a refundable bond be included with that complaint, because then the complainer, which is the word I used, would be able to make any kind of accusation, and then the division has to go out and go into that. If they had to put a refundable or non-refundable bond up with that complaint, it could probably help streamline quite a few things. Your physician's number it was extremely hard once I moved back here to Nevada from Oregon to get a physician to go ahead and give me a license here in this state. So having numbers, what is too high? Also, in 138.3, the division will ensure that there's a log available for law enforcement 24 hours a day. I would also ask that evidence that the registry was used before the officer contacts the patient caregiver. That's pretty easy. You can get a readout or anything with a timestamp on it. Might keep that poor gentleman in Nye County from being held at gunpoint on the floor at 2 a.m. or his dog shot, which happens on occasion. The other thing I'd like to say, and I see a lot of people who are too afraid to get up and speak, but this is not the end of the rainbow, folks, and we need to keep working on our legislature in order to make this a better program. Thank you.
Thank you. Judy Collins.
Good afternoon. Judy Collins representing LVP 1. Are we good? Okay. I have a couple of points that I need clarification on, and I think we do. First would be in regards to the non-transferability. Can a husband and wife team hold joint ownership in an establishment just in case one of the spouses were to pass away, that the other spouse can still continue working in the establishment without having to go back, and we'd have to relinquish the certificate and have her start all over again? That's one. Two, in the off event that we would have a member of the LLC go off and get in some sort of trouble, ends up with a felony, not anything to do obviously with the company, how would that in turn affect our LLC, or would it? The third is in regards to the number of building locations that are allowed for each application. We all know that we have to have our buildings selected, architecturals, plannings, blessings, etc. And you could absolutely love the application, but deny it based on the location. Is it feasible or possible to have more than one location with that application? The other is that, I've been told that the building that you do acquire has to have a solid lease agreement with the consent letter, or you have to own the building outright. My question is, can that building not just be in escrow, ready to close with earnest money? It can be refundable. I mean, you'd have something to lose. Could it not be in escrow at the time of application? And the last one I think I've already gotten answered, so I think I'm going to leave it at that. And I thank you very much for your time.
Thank you. Do we have a copy of your written remarks?
No, I will put them together and I'll make sure you get them.
Okay, thank you. Okay, Mike English. Rebecca Gasca. Pass. Kathleen Conaboy. Dirk Gearing. Jeff Fontaine. Adam Mintz.
Hi, Adam Mintz with Steep Hill Lab. I just wanted to discuss something that I had sent over to the department that I don't think is out for everyone to see as it relates to the new sample size chart for testing of medical cannabis. The wording that I wanted to add comes directly from Washington's I-502, and it basically states that independent testing labs may request additional sample material in excess of amounts listed in the chart that is provided here for quality assurance testing. Now, this is important due to the fact that laboratories will not have no way to procure, cultivate, process cannabis, and in order to keep up with things like machine calibration, in order to prove that their proficiency testing to the state or to perhaps any sort of a group that's going to be doing ISO certification, that additional sample material may be needed. So I'd like the department to maybe take that into consideration. I certainly don't think it would be any large amounts from one group. I think it could be done very easily if everybody gave a little bit, and as a result, the testing would continue to remain consistent. I also wanted to discuss the ISO certification. I think that ISO certification is a great thing for laboratories to have, but like Mr. John Hyatt said and other people had mentioned, it does take time. You can't just start a lab and say we're ISO. It's a process. So if it is, I recommend that it's something that the department, the division moves forward with. However, I would recommend that maybe a little bit of investigation is done as to about how long that process takes. For example, in Michigan's newest House bill that they signed off on the 12th of December, they required that laboratories must be ISO certified by, I believe, March or April of 2015. So they've left that area open for the laboratory to come in, get their business and their instrumentation and so forth, and then start the process of ISO certification. Not only does it put puts a burden on the laboratory, but it's something that you want in place because it's going to ensure those labs are operating with a proper scientific procedure, proper protocols, chain of custody, all the things that are kind of tied into what's already implemented in SB 374. So I'd hope you consider those two items. Thank you.
Thank you.
I have a question, Mr. Mintz.
Yes.
So section 119, you mentioned the chart and the sample size needed. Were you suggesting that a provision be made to where if the laboratory needs more sample that be authorized? Is that what you're suggesting, or did I misunderstand?
What I'm suggesting is that laboratories from time to time will need additional sample sizes, not for the purposes of testing the sample for the processor or cultivator, but for the purposes of machine calibration, precision testing, and things of that nature. And so if the division perhaps doesn't agree with maybe that avenue, there at least needs to be some way for a laboratory to be able to get material in excess of the sample size so they can provide both the sample testing, but additionally proficiency testing, calibrations for the equipment, quality assurance testing internally.
I got it. Thank you.
You got it. Thanks.
Okay, Shannon Dobbs.
Good morning. For the record, my name is Shannon Dobbs. I am a commercial property owner marketing my facility for use in the downtown area for dispensary. And I'd like to speak on a couple of notes that have been presented today regarding legislation changes. From a property owner perspective, I want to support the City of Reno's recommendation that was presented by Megan Salcido regarding changes to the legislature or the wording on the zoning situation, making sure that that it does not impact or is not impacted by other zoning considerations outside of the medical marijuana concerns. Specifically, you look at heavily regulated areas like the downtown corridor. You want to make sure that it looks specifically at this situation. And then I'm also speaking as a disabled veteran and a patient that's going to be benefiting from the dispensaries that are going to be erected. I want to make sure that that the state considers the safety and security of the patients as they're looking at these dispensaries. If you get zoning regulations that are too restrictive, you could inadvertently mandate erection of these facilities on the outskirts of town in relatively unpoliced and unregulated locations that could invite banditry and potential preying illegally on this industry. And I want to make sure that that the state considers that and that these dispensaries are primarily located if possible, close to potential hubs of transportation where these patients can easily access it. And that's my primary concern. Just hoping that we can get that on the record.
Thank you. Joe Pollock. John Griffin. Max Del Rio.
Marla and staff, good morning. Thank you for your leadership. Happy holidays, Merry Christmas, all of that. I would like to be specific and concise in my comments today. I will have additional comments before December 30th, so thank you for that. I want to speak on just 3 items today regarding cultivation. And I think the first comment is that the medicine has to come from somewhere. We are seeing in other states that there is not enough medicine for patients. And so my first comment today, and I appreciate the district attorney who asked the question, how many commercial cultivation licenses do we expect to see in the new medical marijuana program in the state of Nevada? We have met and talked about this issue before, and I think after meeting with a number of different professionals, cultivators, growers, even property owners, the 1-to-1 ratio, we believe, is not going to be enough. 66 commercial cultivation licenses will not provide enough medicine for Nevada patients, especially considering our very forward-thinking reciprocity program. Do we have a specific number? Can I offer one today? No. Is 1 to 2 retail, 1, 2 cultivation, which would double the number of commercial cultivation licenses, is that the best number? I don't know. I don't have that science in front of me. What I will say as a possible suggestion, this is my comment to your office today, is that perhaps you consider an open provisional application, different than the retail, for cultivation. And what I mean by that is a possible phase 1, 2, and maybe even phase 3 permitting process for cultivation applicants. It would then tie the commercial cultivation applicant to the property, which is my second comment today. So I believe that the 1-to-1 ratio is not enough, and I would encourage your department to perhaps leave that number open to allow for quality applicants to come in the door. I think Nevada, no one here wants to see the program fail in the beginning because not enough medicine is available for those patients that need it. That's my first comment today. My second comment has to do specifically with Section 72. I'm very excited, as a number of folks that I have been talking to, that we are engaged on the issue of greenhouses. I believe we are moving forward with the idea that greenhouses will be accepted as a part of the commercial cultivation application process. I would like to see more verbiage on that. My comment on greenhouses is that a greenhouse can be secure. It can meet all of the specific security standards. I will say that there are a number of obvious positive environmental impacts that greenhouses can build. And just for your own records, a 25,000 square foot greenhouse can be constructed in 30 to 45 days. So we welcome the idea that greenhouse can be a part of the applicant's application on cultivation. So thank you for that. My last comment is a new comment, and I do not believe you have heard this yet today, but after touring many properties throughout northern and southern Nevada, after meeting with a number of real estate agent and brokers, even meeting with both county and city municipal leaders, folks in the planning department, we have limited space here in Nevada. Specifically, if we recognize certain zoning setbacks, 1,000 feet from schools, 1,000 feet from parks, these are standards that other states and municipalities already recognize. Here's my comment today. Section 105 A and B is very interesting to me. Section 105 A and B talks about suitable size for cultivation facilities and also adequate space. What we are seeing in other states to avoid monopolies and to provide for a competitive application field, also recognizing the importance of secure cultivation facilities. We do not want to have these hubs become places of crime or robbery. How do we do that? I believe the state should consider, as other states are doing, limiting or putting a cap on the square footage of a commercial cultivation facility. After running some numbers, I believe 25,000 square feet can and should be a cap on a commercial cultivation warehouse and or facility. Let me just say this, for the person that argues that a 50,000 square foot warehouse is better than a 25,000 square foot warehouse, I would then say perhaps we go back to my first comment and allow for more cultivation licenses, which would obviously be more applicants and more fees to and taxes to both the department and the state. But I believe that the 25,000 square foot property or space meets the objectives of Section 105 A and B. Thank you very much.
Thank you. I guess I would like to point out in Section 72.3, as I read it, and as the one speaker mentioned earlier, it doesn't really envision outdoor grows, because if you have to have all of your sides and your top opaque, I don't even know how you get an outdoor grow with that. So I don't know that this actually is promoting outdoor cultivation.
I think what my counter to that, and I appreciate that comment, is that a greenhouse, as I have toured in other states and even Canada, is a structural building. It is a structural building. In terms of meeting the specifics, there is technology and science today that can hide the medicine to outside viewers. I believe the other thing that could happen is you could have setbacks or barriers that could be fenced gates that would not allow for outside individuals to actually come onto the property. So I still believe and encourage the department to be open-minded on the greenhouse. I think you put the onus or responsibility on the applicant to show that he or she can meet those standards, but can do it in a way that at the end of the day benefits patients.
Thank you.
Thank you.
Actually, I have a question. So on the square footage and the number of cultivators, the square footage, how big the applications, how much square footage the applications come in, that affects how many are being considered. But I wanted to hear more, if you're willing to share, on your suggestion that a 25,000 square foot cultivation facility and capping it at that. I wanted to hear if you have it, how that benefits.
I'm actually going to.
That's first I've heard.
I appreciate that. I'm going to submit some hard science to you. In fact, I believe the state of Washington has 30,000 square foot cap on the size of their commercial cultivation. Here's the other thing. You don't have a lot of 50,000 square foot warehouses in Nevada. You also don't have a lot of 100,000 square foot warehouses. You do have a lot of 25. It meets the industry of builders. In terms of the space, and let me just say again that the physical structure would be capped at 25,000 square feet. What happens inside is really a miracle, and I don't want to get preachy, but I've been in over 250 commercial cultivation warehouses throughout the West Coast and even in Canada. A farmer or a cultivator or a grower, someone that specializes in creating this plant, a plant that has, as we know, medicinal values, they have different technologies, they have different strategies, they have different, how can I say, practices, industry practices. Also, different plants grow differently. I think at the end of the day, you have to trust that professional to take advantage of that space and do it in a way that meets all of the very important and I believe successful security standards that we already have on the book. My concern, though, is that someone comes in and tries to pull a 100,000 square foot warehouse. I don't believe that to be safe. I also don't have a lot of best practice examples of folks doing that successfully today. I believe that you can increase the number of permits available beyond the 1-to-1 ratio, but cap the size of that building and put the responsibility on the professional cultivator.
Thank you.
Thank you.
Let's go to Mike Hillerby. We actually only have 3 more people signed up, so we might just go ahead and conclude here in Carson and then go back to Las Vegas, if we don't get too lengthy in our discussion.
Good morning. Thank you, Marla. We've submitted electronically, and there's some hard copies in the back, a specific amendment to Section 121, subsection 9. That's the result of discussions you've had on the lab phone calls about pesticides. And the language would say, the Independent Laboratory Advisory Committee shall establish the list of pesticides approved for use in the cultivation and production of medical marijuana and medical marijuana products to be sold or used in Nevada. And the rest of Section 9 would stay as written, with the one exception of adding the word approved pesticide. But we've submitted that electronically, and there are some hard copies in the back. Thank you very much.
Thank you. Mark Terbeek.
Good morning. Thank you for the opportunity to speak. Just a couple of points. I'll try to make it brief. I suggested in some of my earlier comments, and it touches on some of the comments that have been made here today, the concept of a pilot program that would allow Nevada to roll out this process in the best way possible. I think there might be an assumption out there that sometime in 2014, Nevada will issue 66 dispensary permits, and that will have a full-blown operation up and running in Nevada at full capacity in 2014. I think that might be not realistic if one wants to accomplish the best program possible. What I've suggested is a pilot program with a limited number of cultivation facilities, working closely with the state with the highest standards of testing and security, that would establish Nevada as a state that can keep an eye on cultivation, prevent diversion, and prevent what happened recently in Colorado, where the feds came in and train wrecked the process because there was all sorts of diversion happening. The second aspect of a pilot program that I believe is efficacious for Nevada is it will allow Nevada to focus on the medicine aspect of it. There's a lot of aspects of medical cannabis beyond the THC end of it that have medicinal value, and most of the research that's been coming out over the last 5 or 10 years is really exploring that. And it would be nice with this pilot program, with the properly limited number of cultivators, at however many facilities that is necessary to meet the then existing need, to focus on the medicine of it, specifically the CBD issues and the terpene issues that have proven to be have significant medicinal effects beyond the THC component of it. The pilot program will allow the cultivator, working closely with the state of Nevada, to focus on that one, and to, through the proper regulatory framework, have the security that will protect the facility, the heightened security. Once this has been shown to be successful, then that can be expanded out, that model can be expanded out to as many other registrations as is necessary to meet the demand. What we don't want to have is a situation where product is flooding the market, going to all the dispensaries that are immediately issued licenses, the 66 within a year, and it kind of goes off the rails and gets out of hand. You want it to be done right, properly, providing the best medicine without the diversion aspect of it. And my analysis of it is that the pilot program is the way to go, rolling it out in a graduated manner so that the state can really keep an eye on it and make sure it's done in the best way possible. My other comment is simply a note that in the initial draft of the regulations, there was specific criteria, merit-based criteria for labor and employment issues. I think that should be reintroduced specifically as an element of merit-based criteria for the regulations, particularly because that would encourage applicants across the spectrum to partner with an experienced labor player who can provide guidance and oversight as a first line of defense and with experience in working with federal and state agencies on this issue. And then finally, to reiterate a comment that was made earlier, actually several people made the comment earlier, is that there does seem to be confusion in the regulations as currently drafted that would seem to require doctors who are providing advice or lawyers who are providing services or CPAs who are providing services to facilities. They'd have to be medical marijuana establishment agents. I believe that is onerous and not the intent of the legislature or does not serve the purpose of the regulations. Thank you.
Thank you. Okay, Armando Ornelas. All right, Joe, we'll go back down to Las Vegas.
All right. John Mendoza.
No comment.
Is it Dillard Sensky? Richard Sensky.
No comment, thank you.
Sorry. Jennifer Solis.
Do I need to push a button? Hello, my name is Jennifer Solis. For the record, I'm the president of We Can Wellness Education Cannabis Advocates of Nevada. We sent electronic transfer of some of the proposed changes. The first one is section 35(1)A. It should be reworded to say gains a majority ownership interest. Section 37(2) should be changed to say, except for a complaint concerning the cost of service, the efficacy of the medication, or customer service issues. We certainly don't want to have a poor customer service being the basis of a state investigation. Section 37(3), the text should say, the division may enter and inspect any building or premises at any time during normal business hours. Showing up unannounced in the middle of the night is a potentially dangerous situation, especially when guns and product and everything are involved. This should be during normal business hours. Section 41(4), replace A through C with the following. Number 1, develop an understanding of human physiology and the efficacy of different cannabinoids in relation to different ailments. 2, understand the relationship between strains of cannabis and various medical conditions faced by the patient of the dispensary. Number 3, recognize the value of alternative ingestion methods besides smoking, such as edibles, tinctures, vaporizers, etc. Number 4, monitor dispensary information systems and criteria for establishing and managing patient and caregiver profiles to assist with long-term medication management of the patient. Number 5, to learn communication and interviewing techniques to facilitate interactions with all patients, including seniors, disabled, and other individuals who may need assistance with communications. Number 6, understand that oversight requirements, learn to recognize signs of medical abuse or instability of the patient use, and record keeping and security procedures. And number 7, learn how to follow and document inventory control and anti-diversion techniques of controlled substances. Section 41.5, after B, you should add the following. Develop an understanding of human physiology as it relates to cannabis use. To learn and understand the function and how to recognize the primary cannabinoids. Number 3, to learn to educate and recognize the different types of chemical analysis hardware used in cannabinoid testing. Number 4, monitor laboratory information systems and criteria for establishing patient and caregiver profiles to assist with long-term medication management. Section 41.6, replace A through E with the following. Develop an understanding of human physiology as it relates to cannabis use and the efficacy of different cannabinoids in relation to different ailments. Number 2, understand the relationships between different strains in cannabis and various medical conditions faced by the patients. Number 3, understand the importance of strict anti-diversion procedures in this class 1 controlled substance. Number 4, promote quality assurance throughout the facility and the growing process. 5, to learn how to maintain accurate record keeping for quality control and regulatory oversight processes for a class 1 controlled substance. Number 6, learn the nutritional requirements of plants at various growth stages, proper mixing and dispersal of fertilizer, flushing procedures, and post-harvest trimming, drying and curing procedures. Number 7, learn how to safely handle equipment including high-density discharge lamps, electrical ballasts, pumps, fans, cutting implements, and other cultivation equipment. Number 8, learn the best ways to be least harmful to deal with pest, chemical problems, and anything else that may be harmful to the plants, workers, and patients. Section 50, strike this section entirely. There are commercial free speech issues here. The division simply doesn't have the manpower to review every potential advertisement that will be generated from this. The rule would be very burdensome for both the license holders and the division, and I can see lawsuits happening for free speech issues. Number 52, or section 52. Strike this section entirely. Nevada has no usury laws. So who's to determine what is reasonable or adequate? This section is a lawsuit against the division waiting to happen. Section 121.1A should be reworded to state, must receive proper training provided by the division or a division-approved training facility in the proper methods of selecting a random homogenized sample for testing. Section 137, strike items 1, 2, and 3. These are potential HIPAA privacy violations with keeping detailed records on individual patients, and the division needs to minimize the possible loss of privacy by intent or error. There is not a legislative needs to do this. Item 4 has enough teeth for the division to comply with legislation without creating more work for itself or fostering a chilling effect on physicians who seek to provide appropriate cannabinoid therapy for their patients. I'd like to add additional comment to this that I talked to a doctor recently who does 1/4 of all the applications here in Nevada, but it's only 1/8 of his practice. How would you say that he is over prescribing if he does 1/4 of all of Nevada's practice, but it's only 1/8 of his practice? The Nevada Medical Board the Medical Division Medical Board oversights physicians, and the state should not then oversight physicians also. Section 138.2A, this item is duplicative. Cultivation, growing, and producing cannabis are exactly the same thing. And that's all. Thank you so much for your time. This has been submitted electronically also to the state. Thank you.
Thank you.
Do you have any questions?
Not at this time. Thank you, Jennifer.
All right, thank you.
Kurt Jungchow? Jungchow? Kurt? No, Kurt? Melissa Loti? Loti?
Wait.
It's Wait, you're right. My apologies.
Good morning, my name is Melissa Waite. I'm with a law firm of Jolly, Ergo, Worth, Woodbury, and Standish, and I have some written comments that I do plan to submit, but I just wanted to make one comment. I think all of the other items I have been addressed adequately this morning, but one concern with regard to section 35(1)A, I think there are a lot of circumstances that a transfer would be warranted that would fall outside of the transfer period annually. Those circumstances include what we've kind of talked about already, which is a dispute between the members or the shareholders. But there's also circumstances such as death, divorce, disability of those members, a bankruptcy of one of the members, some sort of other criminal conviction of one of the other members that would warrant a transfer mid-year and that would unnecessarily penalize the other shareholders or members of that LLC if they had to wait to effectuate that transfer until the next annual period. So I believe that's my only comment. Again, I'll address all the other items in written form. Thank you.
Michael Jamison?
Pass.
Andre Rhodes?
Pass.
Forrest Darby? Forrest, you here? Daniel Ballard? William Howard Ballard? Barry Steed?
Hi, my name is Barry Steeb. I'm a part of the Third Day Creation team. I first want to say thank you to Marla and your entire team for allowing us to be part of this process. I think it's important to have everyone on the same page and for allowing the best business practices possible. I'll try not to be redundant in anything that I say and will be brief. Limiting access, limiting the businesses in any way, limiting product, limiting ownership, limiting hours of operation, I don't think is best for the businesses or the patients. I think that allowing access to patients through keeping the cost of the cards as low as possible, again, extending hours of operation, are all things that are going to be beneficial not only to the business but the patients as well. And one thing I would like to see addressed is allowing for more opportunity for Nevada citizens, having a percentage ownership that would be at least 50% or a number that is reasonable for the state, I think would keep the money in Nevada state coffers. I know that Washington State, for example, you can't even finance the business. You can't even give the business a loan if you are not a resident of the state of Washington. And that's to, again, allow for opportunities to Washington State citizens. And I'd like to see something similar to that, not necessarily having full ownership, but allowing a minimum ownership be from Nevada citizens. And to kind of fill the gap, and this is something that I discussed previously, was another way to increase opportunity for Nevada citizens is to allow patients that are allowed to grow for themselves, continuing to allow them to grow for themselves, and maybe sell X amount of pounds per year from a small-time grower. This would put the money into pockets of smaller individuals that would be able to sell 5 or 10 pounds per year to dispensaries and may be able to help fill the gap if there's any time where a dispensary is not able to locate medicine for themselves. And that is all I have at this time.
Thank you. I think they locked up. You there, Marla?
Yes, we're still here.
Sometimes it locks up, so. Let's see, Jay Matos? No? Jay?
Hey, no comment.
Jay? No comment. David McDowell? Kimber Luciano? Do you want to comment?
Yes, I would like to comment.
Just come on over here and sit down. Thank you.
The only comment that I would really like to make is in regards to the safekeeping and security measures of.
Can't hear you.
Okay. Those individuals, caregivers of several different patients. My question is, there's an area there of concern over whether or not their patients are actually receiving the product that that they're supposedly administering to them. I can just see an area of fraud there where certain caregivers are being given an open license to just distribute marijuana if we don't know whether or not it's being distributed to the actual patients. So there needs to be some sort of method there of clarifying that, tracking that. And that's all I have to say.
I'm sorry, Joe, we didn't get her name.
Kimber Luciano.
Thank you.
Harrison Gale.
Hi, yes. Thank you all for being here and happy holidays. I would like to request a clarification and offer a comment. First off, for the clarification is in section 26, subsection 3A. It says this is in the proof of funds, you're requiring $250,000, but these must be unencumbered, but there's nothing that says that it has to be solely for that applicant. I don't see anything in the letter of the law that would prevent one ownership interest from pointing to the same pool of $250,000 for their cultivation, their dispensary, or their edible thing, and I just want to clarify if that you have to have $250,000 for the exclusive use in each one, or it's the same pool of money. And for my comment on the idea of capping the size of these growth facilities, I can't see any logical reason why 25,000 square feet is a good number. I think it seems like an arbitrary and onerous overextension of the regulation. I have been a farmer my whole life, and I've toured, some of the most technologically advanced greenhouse facilities in the world, and these are sometimes in the order of hundreds of acres. In terms of just medical marijuana, the most advanced medical marijuana research facility in the world is in Israel, and that's about over 105,000 square feet. So I think that limiting it at 25,000 doesn't make any sense. Thank you.
Thank you.
Let's see. RJ, you want to come back?
Yeah, I'll throw in what he was saying. It makes sense.
Oh, if he?
Yeah. It's RJ again. I just had a kind of to second what the last gentleman was saying. If you restrict the size, cultivators are quite resilient. We will find other ways to cultivate the same amount of product in the same space. So we will just go up. You'll see facilities that are double-decked and triple-decked. So it doesn't make any sense whatsoever to restrict the size of the cultivation facility. And there is adequate math to show that a 1-to-1 ratio is can produce an adequate supply of medicine for the dispensaries. The challenge is the time frame of when that facility actually launches between the dispensary opening and harvest coming down in those cultivation facilities. So there's a gap that hasn't been addressed. So if dispensary opens 1 month and 6 months later the cultivation facility is open, there's a 6-month gap of lack of product in the marketplace. So addressing some time frames might assist that tremendously. And then to say that one facility, you need multiple facilities with as much space as they want, because there has to be massive diversity in the genetics and the strains that go into these dispensaries. An average dispensary is going to go through 140, 150 strains a year, just from a business standpoint. So if you limit cultivation size, all you're doing is limiting everything. It doesn't make any sense whatsoever. If somebody wants to do 100,000 square feet, more power to them. It just makes sense. And it's a much safer facility to function in versus limiting them to 25,000 and making them do things that they could do in a much safer place in 100,000 square feet. So, and the smell would ask for some leniency on that. No matter how many UV filters or carbon filters we're going to put in a facility, there's going to be some amount of smell. So just addressing that from the get-go and having some way to work with us in the beginning for anybody who's going to be cultivating would be hugely appreciated, because that is going to be a difficult challenge to have zero smell. So that's all I wanted to add. Thank you.
Thank you. So Joe, are you at the end of your list?
I am. Is there anybody else that did not sign up that wants to speak? Go ahead and I'll get you to sign up later.
My name's Vic Salerno. I'm here for Dr. Jeff Raber, who's out of town, who has the workshop. And two things he wanted me to relate to you about labs. A lab can only be a lab, not a processor also. I think that it needs to be changed. You can process material for some and be independent of others. That isn't impossible and certainly should be allowed. Ideally, you can do both for the same clients and it could be more economically efficient. Ideally, what we are planning in Washington is that a cultivator processor can contract the lab to process material under contract. Never own things, only possess, and then test it as well. Then you can get good testing done quickly and no one ever wants to skip the test. Sampling is a whole lot easier too. This is similar to the customer crush model in alcohol or chrome plating of rims on cars for two examples. Pharmaceutical industry does this all the time with contract manufacturing organizations as well. Labs have a lot of great expertise. Why not allow them to exploit it? And the only other thing that Jeff wanted me to bring up is that the residual solvent limits are too high at 500 parts per million. They should be more like 50 parts per million. And I'm sure that Jeff will follow that up written for you. Thank you.
Joe, can I make one? Sure. Adam Sternberg. I already made one comment. I would like to just add one more thing on the rights and application process of the patients themselves. I understand there's no leniency period for expired patient registry cards. So some sort of grace period for expired patient cards so they don't have to go through the complete process of re-registering, costing expenses to the state and to the individual themselves, unnecessary, going through the, for example, the fingerprinting process and all of this again is just unneeded and unnecessary. So we need some kind of a grace period for expired licenses of patients on a yearly basis. Thank you.
Thank you. At this time, I'd like to, if I could, just go ahead and go through some of the other written comments that may or may not have been addressed today. From the division's perspective and the regulations that we're offering, if you have our document in item 1, we are going to propose clarifying the measurement for the distance requirements to say that the distance must be measured from the front door of the proposed medical marijuana establishment to the nearest main entrance that is generally used by the public of the school or community facility. We're going to also, in section 28, replace the term license with certificate, make some technical corrections in section 76 for paragraphs A and B of subsection 2 by just adding parentheses where we should have had them. In section 77, we're going to replace on the label TLC with THC. In the table in section 119 under the product related to the extract of marijuana made with food grade glycerin or propylene glycol, we're going to change that from 1 gram to 20 grams. In the table in section 119, it will be further updated to sync with the text in the regulation. We will release that once we've got the revisions made. In subsection 5 of section 21, we're just going to add to the opening part of subsection 5, except as otherwise provided in section 128. We are going to delete subsection 6 of section 121 and replace it with table 9 from the American Herbal Pharmacopoeia monograph. And again, we have provided a copy of that for you, but we will release all of this on our website. In subsection 7 of section 121, we'll correct all occurrences of aflatoxin rather than aflatoxin and replace it with aflatoxin and aflatoxin O1 with G1 and aflatoxin O2 with G2. And then in subsection 8 of section 121, we're going to delete BW day. We also got written comments from Hardy B, asking for amendments to section 37 related to physicians, asking for amendments to section 73 to allow for patients who may have difficulty opening products to opt into purchasing medical marijuana with easy open packaging. In sections 57.5a, 59.2, and 67.1g will to reduce the required length of record retention from 5 years to 1 year. In section 39.2, strike must revoke and replace it with may revoke or suspend. And in section 78G and 79M, strike has and insert may have, and strike may be habit forming. Section 26.3, amend it with an opening provision to read verifiable documentation which demonstrates. Again, we'll make this available on the website so that you have better context. Another comment received online from Jesse Alexander. Similar comments to the ones that just identified. Same for Victor Marin. We've got comments from Michael McGuffin with the American Herbal Products Association, asking for section 58. If this section is intended to address all transportation of marijuana or marijuana-infused products, including transportation between medical marijuana establishments, such as between a producer of a marijuana-infused product and a dispensary, and not only to delivery to individual patients or caregivers, the 10-ounce limit may be prohibitively small. And we don't intend for that section to limit transportation between a cultivator and a dispensary. It's just to patients. Section 77, paragraph 4. The dates of final testing of the product and packaging of the product are likely to be different in many cases, so these should be separate pieces of information. Section 77, the format of this section should be the same as section 78, with 1 being the list of requirements and 2 being the sample mock-up. Section 79, paragraph 1J, the requirement to identify allergens should be limited to major food allergens, and a definition for this term should be provided. Section 87, paragraph 1B, it seems strange to include mention of animal products like beef, lamb, pork, etc., as these ingredients are unlikely to be used in medical marijuana facilities. Section 88, paragraph 3, same comment as above about animal products. And 95, paragraph 1A. In section 101, he identifies issues with paragraph 4 and paragraph 7 about the 500 parts per million. Identifies concerns with paragraph 7 of that section as well. And then in section 121, paragraph 8, it would be helpful to specify what body weight assumption should be used for the calculating acceptance. And finally, section 125, the limitation to not more than 7 members effectively caps the number of labs. Mr. Del Real did provide comment today. We will review this to see if there's anything different that needs to be posted on our website. Timothy O'Reilly and John O'Reilly. They provided written comments related to section 26. Section 51, section 52, 53, 55, and 79. And again, we will make those available on our website. And then lastly, I have a letter from Terry Cesarson from Perry Johnson Laboratory Accreditation relating to section 124 and the accreditation. So again, we will post all of that. As indicated, we will have a hard date of December 30th for accepting any additional written comments. That would be in relation to comments received today or other items that you identified later. And I'll come back to Carson City. Is there anybody else that wants to make any additional comment? Please come up and identify yourself.
Just real quickly, Adam Mintz with Steep Hill Ham Labs. In reference to the comment made earlier for the representative of Jeff Raber in Las Vegas, I think it's extremely important. It's very important that labs and laboratory employees in no way take part in any production, cultivation, or distribution of cannabis or any cannabis-related products. I think this taints the idea of them being a third party. I think it could lead to a lot of conflict of interest. I just think that it's just a smart idea to keep the labs third party, keep them out of the business of distribution, cultivation, manufacturing, and let them be there for quality assurance and quality control. Thanks.
Thank you. Anybody else here in Carson? Joe, looks like you don't have very many left down in your room. Anybody else in Las Vegas?
I had it turned off. It turned off the mic, and everybody was laughing when you said that. There's still quite a few people here. Anybody else? No, we're done.
Okay. Well, again, thank you, everybody. We're close.
Closer.
Thank you.
Thank you.
Closer, yeah.
Well, it will have to be primarily
What's happening? How are you?
Anyhow, thank you. I'd like to please do email me.
Yeah, I did. Yeah, I went. Yeah.
Wasn't it? Like the old days.
Nice work.
No, I don't know yet. I'm gonna see what their plans are. Yeah, I've got a 2:30. What time do you Well, it's 2:30, so let me get out of here. I'll call you to see what you're looking at, and I want to touch base with our buddy Sean, to make sure that he is still on board. Shane, Shane, yeah. Just want to be sure he's still on board. So I'm gonna say that. She's got to tell me. Yeah, I'm gonna come back. Well, we're just gonna have to see. I'm gonna get out of here and see how quick. Yeah, I'll call you within 30 minutes. Thanks.
You all walked away and left me here.